Awesome. Well, we're almost ready to start. I'm going to record the presentation so that we can go back and watch the recording. If you have any additional needs, you can view them. We'll send them out at the end of the meeting. I do see that Angela has just arrived in the meeting, so thank you so much for joining. My name is Ariel Green and I'm with Care Partners. For those of you that are not familiar with Care Partners, we are a local nonprofit here in Houston, Texas that serves older adults and family caregivers, including older adults with dementia. So the way that we do that is a number of ways. One is through our caregiver education program, which is why you are here today. Some of you all may be connected or have connected with us through AARP. They are our sponsor for today's workshop, and so we'll hear from them in a few moments. But we also offer a number of other programs, and I will put all that information in the chat as well as in the follow-up email. We provide caregiver consultation. So if you are a caregiver and you're needing one-on-one support, we primarily serve those in the Houston, Harris County area, but we can connect with you if you live somewhere else and get you connected to resources. We also have a gathering place program, which is a 3.5-hour program for those that have dementia, as well as a dementia day center. And all of those programs are in the Houston and surrounding areas in Houston, Texas. So I know that some of you all may be from different parts of Texas or even outside of the state of Texas. And so definitely connect with us. Let us know how we can support you. I'm going to turn it over to Rose and Angela. I am going to make you a co-host so that you will be ready to queue up your presentation. We are happy that y'all are here. If you have any questions, I'm going to fade out into the background. I'll bring Angela on, but I will be able to monitor the chat. So we're really happy that y'all are here. Rose, I'm going to turn it over to you.
Okay, good afternoon, everyone. I am so pleased to see we have almost 100 people on with us this afternoon, and I am just so excited. Well, again, welcome and thank you for joining us. I am Rose Childress, an AARP volunteer. And I've been volunteering with AARP for the last 8 years. And excited to be doing that. So a little bit about AARP. We're a nonprofit, nonpartisan member organization that's dedicated to providing information and resources that are important to people 50 plus and their families. Now, our social mission is to empower people to choose how they live as their age through educational offerings such as this, like our caregiving workshops, our cooking classes, legal workshops, and a host of other engagements. And these offerings provide our members and families with information and educational tools that are helpful in their daily lives. Now, our founder, Dr. Ethel Percy Andrus, was an educator and believed that people could choose how they live as they age. Now, if you're interested in learning more about us or becoming a member, then visit us at www.aarp.org/nearyou. I just wanted to make mention of AARP as a resource, a caregiving resource. We have different sessions along with our partnerships with Care Partners, and this is going to be a 3-part series. So I hope to see your faces on the next two sessions. And caregiving is very important, especially here in the state of Texas, where just in 2010 there were over 5,000 folks. It's 65 plus, and no, I must have put a comma there wrong. But anyway, we are one of the states with the largest 65 plus population. And so, it's growing every day. It's growing every day. But if you'll go to the AARP.org website, you'll find all kinds of information, and just put the AARP.org/caregiving, And you'll find articles, you'll find videos, and information about things such as mealtime, making it easy, how to store your legal documents, how to prepare a digital estate plan. So, so please, I want to invite you to go to the AARP website for that information, and also for some of the fun things that we have to offer. We have fun with a purpose, giving you opportunities to socialize. And also, as this past weekend, we had a shred event here in Houston. And if you're not in the Houston area, I'm sure in the other areas, there they have other opportunities for the shred events, which is part of our initiative to prevent, to help to prevent fraud and scam opportunities. So I'm going to pass it back to Ariel Green. And again, thank you for joining us.
Thank you, Rose. Thank you for supporting us and being here today. We really appreciate it. And so I'm going to turn it over to Angela Odensky, who is no stranger to Care Partners. She is a huge advocate in supporting family caregivers as well as older adults. And we are so happy that she's here today to share her knowledge and expertise. So you all are in for a treat. I always learn something new, even no matter how many times I've heard this presentation. Angela and I go way back to, I think, like 2015, pre-COVID days. So we're happy that you're here, Angela. I'm going to turn it over to you so that you can share your screen and share your knowledge and expertise.
Thank you so much. I'm going to share my screen. And if you guys, do y'all see the little screen up that says the Law Office of Angela Odensky? Yes. Okay. Head nods, all I need. That's great. So yes, my name is Angela Odensky. I'm a certified elder law attorney in Houston, Texas. And what that means is that I have a specialty practice that focuses on elders, families, caregivers, people with special needs, and helping manage the legal complexities of these monumental transitions and changes that we all experience, that we all have to go through. I have a little bit of extra training in sort of helping kind of manage expectations in terms of like dementia, cognitive decline, things of that nature. So I have a 3-part series. I'm so excited to see all 100 of you back again. This is incredibly exciting. Like Ariel said, we go back many, many years, and in that little, we could never have fit 100 people in that little room in the facility on Aberdeen. So welcome to everybody. Today, we're going to talk the basics, right? What are the essential documents that you need to have in your toolbox to make sure that your wishes are met? One of the things that Rose said really caught my attention is the AARP, the founder of the AARP, wanted to ensure that people were able to make decisions as they age. They were able to maintain and control their own destinies. And I think that is what everybody who works in the senior services, we're all sort of working towards that goal. Dignity, aging with dignity, aging how you want, being able to plan and make the decisions that you want to make as you age is the number one, that's the best possible thing we can do for our loved ones, for ourselves. So I will start this. Okay, so estate planning is about control. It's about just that thing, right? It's about controlling your legacy. It's about controlling your decisions, controlling what happens as you age, having a picture of what you want to happen as you age. It's not necessarily about tax planning. A lot of people think estate planning, well, I don't have an estate. Well, estate planning is more than just dealing with taxes, right? Because the estate tax exemption for an individual right now is like 12.9 million. Most of my clients are not, I don't deal with taxable estates, to be completely honest. I just don't manage, my clients just aren't managing that kind of money. And so it's more about control. It's more about being able to determine your own fate. Right. That is what modern estate planning should be. You should be looking at it. Even when the current exemption sunsets in 26, it's still going to be about 6 million, 7 million per individual. Okay. Reasons people don't want to do this, right? Nobody wants to do this. You have to think hard thoughts and you have to consider things that you don't want to consider. And maybe you have other people in your life that don't want to have the conversations that you need to have. Maybe you're the one that doesn't want to have the conversations that you need to have, right? People are intimidated by the process. Oh, I have too much stuff. I wouldn't even know where to begin. I don't know. I don't know what I don't know. I don't know what I need to do. I don't know how to gather everything. I don't know where anything is, right? So they're intimidated by the process. How do you eat an elephant, right? One bite at a time. You got to start somewhere. So you start with contacting someone who gives you a to-do list. Homework. It's the best possible thing for anybody. They don't think their estate's big enough to plan for. It's not a matter of the size of your estate. It's what do you want to have happen to it? How easy do you want to make it for your family to be able to manage your estate, both during your aging process, if you are incapacitated, right, and after you pass. They think going through the process of estate planning is too time-consuming or expensive. It can be. It can be time-consuming, and depending on what it is that we're doing, it can feel expensive. It's more time-consuming and expensive for your family when you don't do it. So it's better to go ahead and get it done. That way, you know it's done the way you want. You lose control over the entire process if you don't take care of it yourself while you're able to. People don't want to talk to strangers about their family or their money. That happens a lot. Just one of those things we have to get over, right? Like nothing just happens automatically. We have to plan for things. People have to know what we have in order to plan. And the most important one, I think, people don't want to think about their mortality. No one wants to think about aging. They don't want to think about becoming frail. They don't want to think about, death and what happens when they die. Or they don't want to think about it for their loved ones. I often have couples where, one spouse or the other gets very emotional during the signing process, like when we're doing the signing ceremony for the wills. And it's not they're worried so much about themselves, is that they don't want to think about their partner. Having like, what's going to happen if they're the ones left? These are really difficult things to come to terms with. When it's over, though, you've signed it, it's done, you can go celebrate, have a glass of wine, let those thoughts kind of settle back down to the background again, right? We have to do it even though it's uncomfortable. And it is uncomfortable. Okay, so here is your top 7 list of documents that you should have, right? A will or a trust. That is going to depend entirely on what your circumstances are, as to if it's going to be a better option for you to have a will or to have a living trust or to have some other kind of trust, right? That's what you talk to your estate planning or elder law attorney about, is what is going to be in your best interest, what documents. Your durable power of attorney. The durable power of attorney is the single most important document that you can have in all of your documents, because there is no one that's entitled to touch your money besides you if you are incapacitated. No one can write, if you don't have an agent under your power of attorney, or you haven't set up some other kind of arrangement giving somebody permission to do things on your behalf. We don't have a statutory scheme in Texas that says, next of kin can manage my accounts. That doesn't happen. We have to name somebody. We have to plan for it. We have to have it put together. And your durable power of attorney is the document that does that. And you can include special powers that allow your family to do the kind of planning that you need later, that you might need later on. And so the durable power of attorney is the most important of all the documents we're talking about. Your medical power of attorney is very important to make sure that you have the person making medical decisions for you, who is the person that's going to make the decision you would make in the moment on your behalf. HIPAA authorization, making sure that your family can talk to the doctors, or more importantly, that the doctors can talk to your family, right? About what's going on, about, if you're in the hospital and your oldest son comes in and says, hey, doc, what's going on? If the oldest son's doesn't have any authorization under that HIPAA, then, the doctor would be within their rights not to say anything, right? So we need to make sure that we have these people in place. Your living will physician's directive, designation of guardian prior to need, and appointment of agent for disposition of remains. All of these have specific places and purposes. And I'm going to go over all of them in more detail as we go on, but this is the list. And I think you all should have received the handout that has all of my slides on it. So you should have these. You shouldn't necessarily have to be writing down all of these, scribbling, vigorously. Okay. So the most important two elements of your estate plan, your people and your things, right? Who are your people? What's your stuff? How do you want your stuff managed? Let's take all the mystery out of it, right? This is not a mysterious process. It is who's in your life that can make decisions that you trust to do things, and what do you have that you need them to do things with? We can simplify this all down to those two phrases, your people and your things. A will is just instructions for how your people deal with your things. Again, there's no mystery to this. This is not some big, huge, opaque kind of process. Now, sometimes there is some language in a will that can be very opaque. We have a lot of boilerplate language that is created by attorneys and courts for purposes that may or may not apply to you, but oftentimes it's better to have those provisions and not need them than to need them and not have them, right? So sometimes the documents can be a little bit opaque if you're not accustomed to reading them, but the process is not. The process is very simple. What do you have? What are your things? What do you own? Home, car, maybe some mineral rights. You live in Texas. Maybe you have your bank account, right? Your IRAs, 401ks, maybe a life insurance. These are kinds of the things that we own. If you live in rural Texas, you might have some tractors, you might have some trailers, things on farmland property. So what do we own? How is it owned? Do you own it with somebody else? Do you own your property jointly with a spouse? Do you own your bank accounts jointly with a spouse or with an adult child or with a parent, right? How do you own it? This is the important things to know when you're creating a will and when you're creating an estate plan is what do you own? How do you own it? And is there some other way that it's going to pass? I had a conversation last Friday with a group of people. They call themselves the soloists, and they are people who are aging solo. They don't have a lot of friends, or they don't have a lot of family. They have friends, they don't have a lot of family. And so the questions are, who can we rely on to make decisions for us? What can we put in place? And a lot of it, a lot of questions came up about, well, I have these beneficiary designations that I'm just gonna set this one person as my beneficiary, and then they're going to distribute it as per the terms of my will, but that way we can avoid probate. Well, that's not a good idea for a couple of reasons. When you set a beneficiary designation, it passes outside of your will. So even if you do probate the will, it doesn't matter, right? So those terms of that will are irrelevant if you have a beneficiary designation. So like your IRA, your life insurance has beneficiary designations. Those go to the people that are listed. Doesn't matter what your will says, that beneficiary designation is going to trump, right? And so these are considerations. These are things you need to talk to your attorney about when you sit down with them to discuss what your estate plan looks like. You need to know these things. A lot of people wonder, it's like, how do I own that account? Well, I know that my adult child can sign on my checkbook, but are they listed as just a co-signer without any kind of right of survivorship? Or are they listed as a joint owner with a right of survivorship? That's going to matter a lot to your estate plan. And so these things are data points. They're information that you should have at hand when you're ready to sit down and do your estate plan. What do you own? How do you own it? Who else is involved in the ownership of it? Does anyone else own it with you? Community versus separate property if you're a couple. And if your spouse has passed, was their estate probated, or did you do anything to their estate to pass their property to you? So this happens every day, day in and day out. I get a call from somebody whose spouse passed 15 years ago. They owned their bank accounts jointly. The living spouse stayed living in the house. Nothing changed. Nothing needed to change. And now the mom needs to sell the house. The surviving spouse needs to sell the house so that they can go move into an assisted living facility and use those funds to pay for their care in an assisted living facility. But they can't sell it because they didn't ever do anything to pass their spouse's portion of the house to them. Because just because you own a house together as community property in Texas, it does not mean that there's an automatic right of survivorship. It does not mean it automatically passes to the surviving spouse when the first spouse dies. So what you end up with is a situation where the surviving spouse owns half the house, and the spouse who's passed, their estate owns half the house. And so we have to do something to transfer that interest that the estate has to the surviving spouse. There's a presumption in Texas that there might be unknown heirs, right? So there might be somebody out there who is a estranged child or a child from a previous relationship or whatever. There might be an unknown heir, and we don't just automatically disinherit unknown heirs, right? And so if there's a will, we can probate the will, it passes to the spouse and we're done. So we've done it through the legal process called probate. If you don't have a will, then we have to often go through something called a determination of heirship, where we determine that the spouse is the only heir. We don't want to have to do that. They can be a little onerous. They can cost a little bit more and be a little bit more time consuming, right? So this whole, is it expensive and time consuming to create an estate plan? Maybe it feels that way now, but it can feel so much worse later on if you don't. So that's really important. That comes as a shock to a lot of people to find out that they don't own their house outright just because their spouse passed. Even when they bought it together in 1950 and they lived in it this entire time, it's still, you have to do something. Then where do you want your property to go? And who is going to be the person who's going to manage all of this stuff, right? Who's the executor? The executor has a big job. Sorry, I have to sneeze. Nope, might be okay. Okay, so your executor has a big job. Your executor's job is to hire the probate attorney, right? Collect all of your assets, make sure they know where everything is, pay all the debts, and then distribute out to your beneficiaries. It's very straightforward, the job that an executor has, but it can be a lot of work. And so it's really important when you're choosing an executor that you choose somebody who might be of a generation below you, right? Because if you're in your 70s and your sister who you live with is also in her 70s, then, as you continue to age, so does she, and she might not be able to manage your estate when you're gone. So maybe we need to look to a generation below. Somebody who can cross the T's, dot the I's, who's reliable, will return phone calls, right? It can be a big job. All right, giving your things to your people at death. Your things don't automatically pass to your people, right? So that's what I was kind of talking about with the house. It doesn't automatically pass from the estate of the deceased spouse to the living spouse. We have to do something about that. That's true for everything you own. We have to have something on it that says what happens to it at death. Your will says what happens generally to all of your stuff. It's called the residual clause, right? If you have a residual clause in your will, that is everything else. If they didn't list it specifically, everything else, this is how it goes, right? But you could have beneficiary designations, which we talked about, right? So those are your IRAs, 401ks, life insurance, anything where, somebody has allowed you to come in and say, this is who I want to get this, and this is the percentage they're going to get. You can pass it via a will or a trust. And again, I'm not really going to go into the differences of those things because it's going to be very fact specific to your circumstance as to whether a will is a good idea or a trust. A trust can avoid probate. Probate doesn't have to be incredibly difficult. So depending on your circumstance, probate avoidance may not necessarily be necessary, right? Or it passes via state law. So if you haven't named somebody as a beneficiary, you don't have a will, you don't have a trust that passes it in some way, there's no transfer on death for anything, then Texas law has a really, or Texas statute has a really detailed chart that says who it gets passed to, who takes it, in what portions, how it gets divided up. And so if you don't say who does, Texas already has it all laid out for you. All right. The things that go to your people outside of your will, right? So we talked about how your will controls some things, and then other aspects control other things, like those beneficiary designations. A will does not control anything in a beneficiary designation. Anything that has a right of survivorship, so like that bank account, that this comes into play a lot. An adult child is the one that's on the ground, that's helping mom, that's doing all the things that need to be done, you know, paying the bills. And so it just makes sense. She puts him on her bank account. They own it together. There's a right of survivorship. And then when she passes, that adult child owns that bank account outright, period. Doesn't matter what the will says, doesn't matter anything else. There's a right of survivorship. That adult child just gets those funds, which is problematic no matter what the circumstances are. If the adult child is a good actor and wants to make sure that those funds get split between the siblings, now that adult child is responsible for gifting that money that belongs to him, for gifting it, which is a specific tax term, right, to his siblings. I say his because this actually happened to a client of mine. He was on his mom's account when she passed away. It was like $400,000 or something in that account. And he absolutely was 100% going to split it amongst his siblings because that's always been the plan. And he wanted to follow his mom's wishes, 100%. Well, now he's got to go to his accountant. He's got to file gift tax return. He doesn't have to pay gift tax because it's well within under the exemption. So there wasn't like that extra, but it was just extra administration he had to do. Like there were more things he had to think about. It wasn't so simple, you know. And then you have the other side of that where the adult sibling has no intention at all whatsoever of sharing it with their other siblings, no matter what mom wanted. And so I get that call too. It's like, well, what can we do about that? Well, there's not a lot you can do about it because they were joint owners of the right of survivorship. That person has 100% right to access that account and do whatever they want to with it. It's their money now. So knowing how you have your accounts is so important. I had one couple who the husband passed, and they didn't have rights of survivorship on their bank accounts. They were owned in another way called tenants in common. And so the bank accounts all got frozen and she wasn't able to access their bank accounts where all their money and bills and everything were going out until after the probate process happened. That was difficult, right? So knowing how you own your things and how those bank designations are made is so crucial. It's so crucial for later on. If you have a beneficiary designation, it automatically passes to the named beneficiaries, regardless of what the will or trust says. And that's true for pay on death designations and for bank accounts. Anything that sort of where you sign something saying, when I die, I want this to pass to somebody else, that's going to pass it outside of the will. It's going to pass it outside of probate. So like Texas's transfer on death deeds for your house, those work like a beneficiary designation. They just pass the moment when you pass, that property passes to your beneficiaries. All right, so let's talk about the details, right? What is a valid will in Texas? So I hope I hope that this call has great reach. That would be wonderful. So if there are people here from out of state, I'm sorry, everything I'm about to talk about is all generally going to be Texas specific, right? Because a state law is state law. So just make that disclaimer right there. So for a will to be valid in Texas, the person creating the will has to have capacity, right? So they have to have legal capacity, meaning that they have to be over the age of 18, and they have to have testamentary capacity. And what testamentary capacity means is this notion that the person who's signing the will, at the time they're signing it, they have to know what they own. They have to know who their people are. They have to understand that they're making a will, and then they have to understand that by making a will, they're passing their things to their people at their death. And they have to hold this thought together all at the same time while they're signing. It's a fairly low bar, right, to be able to execute a will. You don't have to, there's actually case law where somebody like knew she owned a house and she wanted to make sure that her sons got her house. Now she thought that her house was in Arizona, right? Because that's where she used to live. And so part of her cognitive decline, she forgot she had moved to Texas. And the judge basically came out and said, you know what? That is not material. She knew she had a house and she knew who her sons were. And so the fact that she was mistaken as to the location of the house didn't mean that she didn't have testamentary capacity, right? So it's a hard call. Simply having a diagnosis of dementia does not necessarily mean someone doesn't have the capacity to sign the document, but you want to be very, very careful if you are executing any of these documents, or assisting somebody in executing these documents who does have cognitive decline. You want to make sure that there are some safeguards in place so that we know that we're getting the real intent. So that's testamentary capacity. And the will cannot have been tampered with. I get this question a lot too. It's very interesting to me. A will is not a contract. You cannot mark out a provision, initial by it, and handwrite in the new thing. That is not going to have any effect in law. As a matter of fact, when we see something that has been marked out, we have to ignore that, right? Because a will, any change that you made to your will, it has to be executed with the same pomp and circumstance as the original will. So like witnessed, notarized, the whole shebang. So it can't have been tampered with, or those provisions. Now the whole will is not necessarily voided. If that's the case, we just ignore whatever the tampering was. So there's two ways to write a valid will: typed, signed, attested by witnesses, notarized with a self-proving affidavit. That is the way to go in my probate experience. That is going to get you in and out the fastest, with the least amount of hassle. This is the way that it's done in most attorneys' offices, right? They type up the will, you go over it, you say, yes, these are the provisions that I wanted, everything is in order. When you time for the signing, there's a couple people from the office there, they sign, they notarize, you have the whole thing, it's all in one package. And then when it's time to sign, it was time to actually probate that will, there's no need to call any witnesses, there's no need to do there's no extra rigmarole, you just submit the original will, and the attorney and the executor go to court and say, yes, that's the will. And we get through the probate process, right? That is the quick and easiest way to do it. Or a will can be entirely handwritten and signed without the need for witnesses or a notary. It has to be entirely in the handwriting of the testator. I have had questions before where people are like, well, if I do it in my own handwriting and he dictates it to me, is that going to be sufficient? No, it must be in their own handwriting. And you're going to have what witnesses who are going to be able to come to court to say, yes, that is the person's handwriting. I don't know when the last time any of y'all wrote a letter was, but it's been a while for me. I think thank you notes at my wedding many years ago, right? So finding handwriting witnesses is becoming harder and harder. All right. Why shouldn't I just make my own will? Because you could create problems you didn't know existed, right? If you sitting down to do the estate planning process is about going over everything holistically, right? It's looking at those bank accounts and saying, this is a right of survivorship. I do or don't want that, right? This is how these beneficiaries are designated. I do or don't want that. I forgot to designate a beneficiary altogether on this life insurance. That's an issue, right? If you don't do all of those things, then you could end up creating problems for your heirs and your estate that there's no way you could have known was going to happen. Everyone wants to say that they have a simple situation, and then they want to tell me about their business and their children from a previous relationship, and oh, but it's so simple. It's like, no, that's not simple. We have to, like, each of these pieces matters, and we have to address them all individually, right? So examples of issues that arise when you have a do-it-yourself, and these are things that I have actually like experienced in my probate practice. Minors unable to access their inheritance because of the way that it was written and who was put in charge of something. That person died and there was no way to name somebody else, right? Making an heir lose government benefits. If you have a niece, nephew, brother, sister, cousin who has some kind of disability that allows them to be for which they receive government benefits, and you decide to do something incredibly generous and leave them something just to help out the family, if you leave it directly to them, you could jeopardize their ability to get benefits, right? So it's important, especially if you're talking to an estate planning attorney, to be like, well, I want to leave these things, or there are these people in my lives who might end up inheriting under this, and is there something that we need to be doing? Yes, there is. I've had this trying to give away money that technically wasn't there, so they didn't realize it. So married couples who've always kept everything separately, the spouse is like, well, I'm going to give everything in my bank account to my kids. It's like, okay, do you have a marital property agreement? No. Okay, well then part of that money might actually belong to your other spouse, right? So we are a community property state, and so there are some rules. And then, like I was saying, no living witnesses to testify to the handwriting. That is becoming more and more. There is a form now. The Texas Supreme Court has approved of a will form that is now available. It has not been tested in court. It does not supersede the need for legal advice, right? Estate planning is more than just drafting a document. It is taking a look at the big picture and coming up with a plan that is going to be what you want. And so simply looking at those drafts may not be sufficient. Mostly, you could just create problems you had no idea you were creating. So should your will include a trust, right? So we have all kinds of different sorts of trusts, but sometimes a trust can be created by a will. If you have minor children, then yes, you'll need a testamentary trust because minors in Texas can't hold property, right? If you're leaving money to a person with disability or who's on some kind of government benefits, then we can have a special kind of trust put in your documents to make sure that any funds that go to them won't jeopardize their benefits, but they can still benefit from, right? So they can still use the money, and it won't mess up their ability to get benefits. That's very important. Did you have wishes beyond just inheritance? If you want to attach strings, you have to have a trust. A will attaches no strings, right? A will says, here's my stuff when I die. No strings attached. If you want to attach strings, like, this person gets to live in this house. Well, no, that's different. But if you want to attach any kind of strings, like this money has to be used for education purposes only. Well, now we're in a trust because someone has to manage that, right? And did you want to leave funds to support a pet? Pets are family too, right? And there are ways that we can set everything up so that you make sure that there's a caretaker for your pet, and that caretaker has a little money set aside so that they can take the pet to the vet, right? To get their shots, to get food, just kind of putting things in place so that your pet is taken care of as well. All right. So again, we're going to take the mystery out of the probate process. Probate is very, very simply taking a will to a judge and having a judge say, yep, this is a will. That is ultimately what probate is. And then the process of carrying out the wishes in that will. There's no great mystery to it. There's no big hullabaloo. It can take time and effort, and it can be expensive depending, but when no one's fighting and everything just needs to go as per is directed in the will, then it's just step by step. You take the will, the judge says, yes, this is a will. Yes, the person named in it to be the executor gets to be the executor. Now the executor collects everything, sells the house, passes the house to the beneficiaries, however that's going to work out, collects the funds, and then pays whatever valid debts are available or necessary, and then distributes all the rest out, right? So you have to have a trust account at a bank, you have to have a tax ID number for that trust account. There's all kinds of little details that come with it. That's what your probate attorney's for, right? Is to help you walk through those little details. But the big picture of what is probate, it's just making sure that the will was validly executed in the state of Texas, and that it is just a validly executed will. Even if it was a will executed in New Jersey, as long as it was executed with all of the requirements by New Jersey law on the date it was executed, then we'll still probate it in Texas, right? So it's as long as it was done the way it was supposed to be done there, then we'll honor it here. So it allows you to go through the process. It confirms ownership. It makes sure that deceased spouse's half of the house goes to the surviving spouse, and it confirms that ownership over the whole house. And it can prevent some unscrupulous credit scams. So if we go through the probate process legally, then part of that is making people who present bills prove that those bills are legitimate bills, right? Because we don't necessarily want to be paying out of the estate funds that are not legitimate bills of the person who passed. And so we have a process for doing that. All right, so that is the will, what it is, and like that's the whole life of a will, right? From drafting to probate. All right, your power of attorney. I've gone over this once already. I'm going to say it again. It's the single most important document you can have while you are alive. You choose the person who's going to make financial decisions for you while you are incapacitated. They are the one that's going to decide, do we sell the house to pay for care? Where are we getting the care? Who are we contracting with to get the care? How much is that going to be? How long are these funds going to last? How are we going to put all this together? That's your agent. It is a big job. It can be an enormous job. But you want to be able to make that decision yourself. And so you want to be able to choose who you want to choose. I recommend having a couple of successors. Name one person, and then someone to serve if they can't, and then someone to serve if they can't, because things happen in people's lives. They get sick. They have family members that get sick. They can't help you anymore because they're dealing with something else in their life. Okay, they can resign and another one can step up, right? Backups. A big fan of backups in these documents for executors as well, but also for also for your agents under the power of attorney. A well-drafted power of attorney can alleviate or help alleviate the need for a guardian later on. So, for example, if you don't have a power of attorney document and you haven't named anyone to manage your finances during a period of cognitive decline, and you have severe Alzheimer's and now we have to pay for care somehow, there's no one that can access your accounts if you don't have something set up, right? Like the co-ownership with the account, co-signer, power of attorney, whatever. There's no one that can do that if you don't have something put into place. And so we have no option but to go to court, have you deemed incapacitated, have you placed into a guardianship, and then now your guardian has to do an accounting of every penny from your estate that they spend every year. They have to go to court and show what was spent, why it was spent. They'll get an allowance to spend on your care. It is long and arduous and onerous, and we want to avoid it at all costs, at all costs. So we draft powers of attorney that give specific powers to allow your agents to do things that can help alleviate the need for guardianship, that can help them plan for things like Medicaid qualification if you need it. If you need nursing home care and you can't afford it on your own, you know, are there things that your agent can do to help you qualify, right? So we draft those in there. Those are not powers that are necessarily going to be available when you pull a durable power of attorney offline. I do not recommend it. I do not recommend that you get a power of attorney from a random online website, because you really want to talk to somebody about this document, what it does, and what special things should be in it. And I have horror stories galore. I was talking to a family 3 weeks ago where they pulled off a power of attorney to sign them. The person who signed the durable power of attorney to give the authority to, you know, talk to me, to do some planning, to figure out what's going on and help out. They did it on their own, and the person gave their agent the authority to manage digital assets. And that's it, because that's all they initialed by, because they didn't go to an attorney to learn what it is that they were doing and have somebody kind of watch over what elections to make. So the agent had the ability to manage the Facebook account. And that's it. That's all the agent could do, because that's all the power of attorney authorized. I mean, digital assets are more than Facebook accounts, but you get my meaning, right? It wasn't done correctly, and there was no way to go back because she had taken a turn, and so we couldn't go get another one. That was not that could have been avoided. Your medical power of attorney, choosing someone to make decisions for you when you're not able to make medical decisions. The key to this document is to choose a person that's going to make the decision you would make if you were able to make that decision, right? So you want someone who knows you and want someone who understands your values and your underlying thoughts on medical care, right? If you do not have this document, this medical power of attorney, then there is a statutory list. Like there is a list in statute that says who gets to make medical decisions for you, absent a document. That's generally going to be, of course, your spouse, reasonably available majority of adult children, parents, right? So we have a statutory list. It's better if you name the person that you want. HIPAA authorization, your eyes and ears. This is not a decision-making document, but it is an information gathering document. It allows somebody to get information from your healthcare providers about what's going on. And so if you have somebody like the example I gave earlier, you know, an adult son who's not listed as an agent under the medical power of attorney for whatever reason, maybe he lives out of state, and so it just didn't make sense to have him listed on the document. And so he's flown in because something's happened with mom, and he goes to the hospital. The doctor doesn't have to talk to him, right? If there's no HIPAA authorization and he's not listed as an agent under medical power of attorney, then he has to wait until the agent gets there in order to be able to know what's happening or to talk to the doctor about that. So the HIPAA authorizations are pretty essential, depending on your family situation. Designation of guardian prior to need. If for some reason we have no option at all whatsoever, and we have to seek a guardian on your behalf because you cannot protect yourself from exploitation, self-neglect, financial exploitation, abuse, you name it, scams. If we can't protect you, and the only way that you are going to be protected is with a guardianship, then you can say who you want to be your guardian. And more importantly, you can say who you don't want to be your guardian. You can exclude people that you don't want to have anything to do with your decision-making processes. And the court will take that into account. Keep in mind that an agent under a durable power of attorney cannot veto your wishes. So if you do have cognitive decline and it is causing you to make decisions that are not in your best interest, an agent under a power of attorney can't stop you. A guardian can, which is why I use self-neglect as well as financial, and self-financial and neglect is part of that. But you can say who's going to be in charge. There it is. I've been waiting for that the whole time. Okay. So you can say who's going to be in charge of those things. There's two kinds of guardians, a guardian of your person and one of your estate. The guardian of the person is the one that chooses where you live, what doctors you see, your day-to-day life, managing all of that. If you have a trust and all your money is in a trust and you just need someone to be able to make decisions for you on like day-to-day things, then we can have a guardian of the person only and no guardian of the estate because we don't need it, right? So we want to limit it to only what we need. A guardian of the estate is the one that has to make an accounting to the court every year and account for literally every penny. That balance sheet has to equal 0 in order to be signed off on. All right, living will physician's directive, making decisions specifically on certain medical treatments while you are still alive or while you are still aware and able to make these decisions, right? It covers 2 scenarios for people who cannot make their wishes known in the moment. And that is if you have been deemed to be in a terminal condition, so you're not expected to live longer than 6 months, or you are deemed to be in an irreversible condition, meaning that all medical interventions have been given and you are not going to get any better. Then you can choose keep me comfortable and withhold or withdraw life-sustaining treatment, keep me comfortable and let me go, or do everything in your power to keep me alive. Those are kind of the options there. It's not a DNR. A DNR is a completely different document. This is more for artificial life support. It's a different one. We have a couple of different medical documents that you can execute that for doctors to know how you want to be treated. This is specifically for life-sustaining treatment when the prognosis is not good. All right. Appointment of agent for disposition of remains. Texas has a document for everything, including who gets to plan and pay for your funeral. That's it, arranging your funeral. Who gets to do it? There are special instructions on that one that says that where you get to say what you want, right? You can also just attach a sheet with whatever detail you want. If you want to be cremated, you can just say, I want to be cremated. And then you put someone in charge of that. And then that is the person who gets to make those decisions. This document feels like a throwaway document to a lot of people, but it becomes very important in blended family situations where dad dies and stepmom wants dad buried where her family is, and kids want dad buried in a different place. Who has the authority to make that decision? Well, the first question I ask is there an appointment of agent for disposition of remains? Because if there is, that question is answered. Dad answered that question when he executed this document, right? It just puts one person in charge of taking care of the final arrangements. If you haven't already prepaid for them, I'm a big fan of, I talk to people all the time about pre-planning for your funeral. There's any number of reasons to do it. For me, the most important one is it's kind. It's just a kind thing to do for your family. Take care of those details so that they don't have to do them in a moment of grief. No, I don't get any kickbacks from funeral homes. I just know that it is a kind thing to do. The families that I have met with whose parents already had everything taken care of just speak so highly of that process. And they're so relieved and so much more satisfied with how everything went out, because the burden didn't fall to them to decide the color of the coffin liner. You know, those are hard decisions to make in a moment of grief, which a lot of people have to do. So pre-planning I'm a big fan. All right, so what happens when you don't plan? You lose your ability to deal with your property. right? And your legacy, you have no choice in the matter. Texas state does. Probate can be longer and more expensive. There are pitfalls you may never have known about. And your property is distributed per statute. So those are the takeaways. Plan ahead. All of the next 3 weeks, I guess, while I'm doing this series, it's all about planning. The different kinds of planning, long-term care planning for, you know, your sort of eventual age and decline. This one's just the first bit. I see a bunch of things in the chat. I got questions. So do you mind, Ariel, if I just kind of start running down them?
Yeah, sure. And I'll also help go through them as well, just so we don't miss any.
Yeah.
Or some of them may be duplicate. So
I don't know what this first question is. How do you obtain all this information from you? Well, you call my office. Like if you want to have a consultation with me to go over your stuff, you can call my office. If there's another estate planning attorney, elder law attorney that you know or want to work with, call and make a consultation. It's worth the cost of the consultation to sit down and figure out what it is that you need. That is my opinion. Including a doctor's judge's authorization to effect power of attorney. Okay, this is a comment. What if you don't have anyone to handle these things? That's a big question. It's a question that we are all, that sort of the elder law bar asks all the time, like who's around. There are some people that you can hire to be there to help you do these things. They're few and far between, and oftentimes it depends on what kind of estate you have, right? The more money you have, the easier it is to find someone to help you out. The less money you have, the more difficult it is to find somebody who's going to be able to manage it, because no one wants to like drain you dry on their fees, is what it comes down to. Wouldn't a Todd deed be sufficient? So a transfer on death deed is sufficient to pass a house from one spouse to another. As a matter of fact, that is a common estate planning technique that I use when I do couples estate planning, is that we will create the will, the powers of attorney and everything. And I will also create a transfer on death deed so that at least we can avoid probate on the death of the first spouse. Transfer on death deeds are great. That, like I said, they act as beneficiary designations for a house. Let's see. Can a beneficiary be under 18? So depending on what you want to leave them, no, right? So somebody under 18 can't take property in Texas. So if you're wanting to, if you set a beneficiary designation on your IRA for somebody who is under 18, what happens is that a guardian or conservator has to be appointed by the court, and those funds then have to go into the court registry until the person is 18. And it gets managed, or it goes into a Uniform Transfer to Minors Act trust. It has to go into something that somebody else is managing on their behalf. There's a couple different ways to do it, but oftentimes it does prolong the probate process, and we could end up having another person being involved who's just there to receive those funds and put them in the right kind of account, and we have to have a judge overseeing it, because a person who's 18 doesn't have legal capacity to make decisions for themselves in this matter. If you have an incapacitated loved one, an agent under a power of attorney cannot sign a transfer on death deed on behalf of someone else. Only the individual can sign a transfer on death deed. So there was a question about whether or not a transfer on death deed would help with the particular problem of helping an incapacitated loved one. It depends on their level of incapacity, right? But an agent under a power of attorney cannot sign a transfer on death deed. There's a couple here that are really specific to their to their circumstances, I'm going to skip past those and go to the ones that are more generally going to be questions that most people are going to have. If you have specific questions and you want to call my office, please do so. An average price range for seeing an attorney to get estate planning done in Texas. There's not. It depends on the size of your estate. It depends on, there's not, especially Texas. Texas is a huge state. You just have to call around and see who you want to talk to. Some people work on a flat fee basis. Some people work on an hourly rate. So I can't speak for everybody on that. And it depends on what it is that you need. Are death benefits from an annuity taxable to the beneficiary? Again, it depends on how those death benefits come through. It depends on what kind of count it is. I don't know. I can't answer that. So tax questions about specific like financial vehicles, I can't answer in a vacuum without knowing the kind of financial vehicle it is and how is this money tax that went in, what kind of annuity is it, like how was it created, is it part of a pension plan? Like there's just too many questions. Those are not ones that I can really address. If a will and a living trust were created in another state, do the documents have to be redone if you now live in Texas? Not necessarily, right? If you have a living trust, that might need to have a provision added if you're going to put your house in the trust, because we have special language that we like that we have to have in our trusts in order to maintain your homestead exemption. And so if you own a home in a trust from a different state and you don't have the qualifying language in the trust, you could lose your homestead exemption. So having that reviewed by an attorney to see if you need to make some state-specific changes so that you don't lose out on the homestead exemption, very important. But it might be it might be fine if you're not putting a house into it, then the other terms might be perfectly reasonable, right? One of the great things about a trust is they just kind of move with you, and that's kind of one of the reasons why a lot of people like them. As far as like the will, like I said, if it was created with all of the requirements when it was done, it doesn't necessarily have to be redone unless you want to make changes. Like the people in it, you want to change the people who are in it. You want to change the beneficiaries, the executors. You want to make some changes, then I would do that. Now, your power of attorney, your medical power of attorney, you do want to have those be Texas documents. Technically speaking, your durable power of attorney should be valid, even if it's from another state. What I find is that financial institutions really hate honoring powers of attorney to begin with, and they really hate trying to honor powers of attorney they are not accustomed to seeing. So if they see a form that they're not accustomed to seeing, the knee-jerk reaction is this isn't valid. And then now you're off to the races just trying to get somebody to talk to you at the bank to deal with that power of attorney. So if you have moved and you have powers of attorney, medical powers of attorney, those do need to be state specific, just to try to like grease the wheels later on if necessary. Can the primary beneficiary also be the executor? Sure. There's no inherent conflict necessarily between being an executor. That happens all the time, right? So couple, 3 kids, all 3 kids, professionals, they're leaving everything equally to the 3 kids. The oldest one lives in town. They name the oldest one as the first executor. The middle one is the second successor, or the first successor, and then the third one is the next successor. And so everyone's just kind of included. It's fine. There's nothing wrong with it. Now, they can't witness it, but they can serve. Can your POA's name be included as part of your will? Absolutely. Your agent under a power of attorney can absolutely be part of your will. Again, when we are talking, like, this is so common. Adults with kids, they name the kids in succession 1, 2, 3, 4 as their agents under the power of attorney. They name those same kids in the same succession as their agents under the medical power of attorney, and then as their executors, and then all 4 split the estate equally. And that is a very, very common thing to do. So, If a decedent fails to name a beneficiary for his 401k, has no will and owes back taxes, can the IRS take those funds? The IRS is going to get their funds. Like that's a determination of heirship and a dependent administration. Like that fact pattern right there is real expensive to get that done. Oh, thank you. Someone blessed me when I sneezed. Do you still need a will if you have a TOD for your property and beneficiaries identified on your monetary? It's a good idea. It's a good idea. Like, it's hard to say need. Do you have a plan? Like, you've done a plan, you've executed things, but your transfer on death, if there's any orphaned asset, if you left something out, then you still kind of need a catch-all. You don't have to probate the will. Your family doesn't have to probate the will. If you have a will, but you've done all of this other planning, and so everything passes outside of the will, then they're done. They don't have to go through the probate process if there's no assets to probate, right? So it's a good idea to have a will, even if you have all of these things, just because you never know if you accidentally left something off. Or if you became if you inherited mineral rights and didn't know it, right? Then we still need to know how those are going to go. And naming an executor who can manage all of those things just makes things easier. So I recommend having a will, even if you have all of the rest of this in place, as a just in case, right? So handouts of the PowerPoint have been made, so y'all should be getting those, which has my phone number in it. Does a list of special bequests require a notary? Yes. If you want, okay, so a list of, if you just have a piece of paper that you write special bequests on, and then you write what you want, who you want it to go to, and then you have it signed and notarized, that's not a will. That's not anything. Like, that is maybe some kind of, I don't know. I wouldn't try to probate that as a will, right? So simply having a list of special bequests. Now, if you have a will that says, please honor any memorandum that I have where I name people and things, then your executor knows to look for that memorandum and they could use that. But as far as that doesn't require a notary. How to designate money for an executor, that's something you'll talk to your estate planning attorney about, right? So that's something that you put in your will, where we talk about the term, and I know it's horrible because the legal terms that don't make sense to regular people. Fiduciary compensation, that's the thing that you're looking at. That's the magic language, right? Fiduciary compensation. This customary, right? So there's a customary amount that's like, I think it's 5% of the amount gathered, but there's some disagreement as to 5% of what. Like, if the executor hires a real estate agent and the real estate agent gets their 6% to sell the house, then can the executor also take 5% since they didn't actually do any work? That would be up to a judge in a dispute amongst the beneficiaries as to whether or not the executor should have done that. I would say that's not a good idea. Like, I would advise my client not to do things like that. But, so executor compensation is kind of it's an interesting exercise that you have to talk to your attorney about as far as what you want. Let's see. What about a small estate affidavit? This is an excellent question. Okay. Small estate affidavits were created for people to have a much more truncated probate process if there's not a whole lot of assets. If you have less than $75,000 in assets, generally speaking, not including your home, then a small estate affidavit will allow you to pass it to your beneficiaries with a whole list of caveats. It doesn't pass your home to your kids. It will only pass your home to a spouse. So you cannot use a small estate affidavit in lieu of a will or a transfer on death deed or some other process for your home. It doesn't work. A small estate affidavit cannot be used if you have a will. So planning to use just a small estate affidavit, like it's there for people in emergencies, right? Who don't have a lot of funds, who need something to get through the probate process. Small estate affidavits are great when you had somebody, especially who was young, who passed, they had $6,000 in their bank account, and we just need to get that $6,000 out. There's no hearing required. They tend to be less expensive. But I will say you have to know the exact amount that's in that bank account, and no one at the bank's going to talk to you without letters testamentary. And so small estate affidavit has their place, but they are so problematic. They are so very, very problematic. I definitely have done some for people in the past when that has been the right option, but it can be, it can be very challenging. All right, 2 different Texas Advanced Healthcare Directive documents, one from LegalZoom and one from Regents of California, which seem a bit more personalized. Which do you recommend? The Texas one is a statutory requirement. So the Texas Medical Power of Attorney is a statutory document that has to be substantially compliant with the statute. And if it is not substantially compliant with the statute, then it is not technically considered a valid document in Texas, right? And so there are great documents that are really robust in terms of like allowing someone to say what their medical decisions are going to be and how they want to be treated, and they exist in other states. They are not binding here. So if you have something like that, like the 5 Wishes document or other documents that you get from other states, they're great guidance for your family, but they're not binding by law because the medical power of attorney has to be substantially compliant for it to be binding by law. Are durable power of attorney and a will from New Jersey valid in Texas? Again, that whole valid thing. If it was created and drafted and written in all the pomp and circumstance of New Jersey at the time, then it is a valid document. When you say valid in Texas, you mean, is it going to be accepted in Texas? Well, the will, I have actually probated a New Jersey will in Texas. No issues at all whatsoever. A durable power of attorney, it depends on whether or not a third party is going to honor it, right? It's not a matter of, it's one thing for me to say, yes, it's valid. It's another thing for you to take it to Chase and have the random person at Chase look at it and say, I don't recognize this document, it's not valid. You can argue until you're blue in the face that, well, an attorney told me it's valid. They are not going to move, right? They are not going to move. You will have to take them to court. You will have to find their legal department. You will have to take them to court to make them do the thing. It is going to cause issues. You might ultimately go up the chain high enough to get somebody who's going to honor it. But the thing is, there's nothing magical about these documents. They don't magically make other people do things that you want them to do just by the sheer fact of their existence. These companies all have their own, policies. And not the people that work at these financial institutions are not attorneys. They are not Texas attorneys for sure. All of this stuff is different from state to state. So this is, all right. So that's kind of is it valid? It's probably a valid document. Whether or not someone will take it, I don't know. Do I need a HIPAA authorization when I have a medical durable power of attorney? It depends, right? It depends on who you want. If you have the people that you want to get medical information are also named under your medical power of attorney, then sure, then it's fine. But if there are other people that you want to have, then you need both. right? So this is something to talk to your estate planning elder law attorney about, right? Do I need both these documents? Well, let's look and see. I've had 2 financial institutions wanted only their durable power of attorney. Is this common? It's very common. Is it legal? That's a different question. They should honor the one that you have, but force them, right? I have financial institutions all the time. So generally what I tell my clients is when you draft this power of attorney, take it to your bank while you still have capacity. Tell them, this is my durable power of attorney, and I want you to put this on file in my file so that you have it. And I want you to, and do you happen to have any other required documents that you need me to sign? Path of least resistance. If they have other things that they want you to sign so they have their own on file, do it. It's so irritating when I get that call. Like, the bank won't honor the power of attorney. Yep. There's, you can engage my services and we can go to court, but that's where we're at. Because again, there's no magic wand. Let's see. Oh, pomp and circumstance. Someone asked me what I meant by pomp and circumstance. The formalities of signing, right? You have to sign with the formalities required by Texas statute. That's what I mean when I say pomp and circumstance. All right. I think I've answered most of the questions. Next week, I will be back. We will be talking about long-term care planning. Eventually, we're going to be talking about like Medicaid qualification in the 3rd week. So I look forward to seeing all of y'all. I am happy to have been here today. Thank you so much for coming and for listening to me ramble. I will be doing more of that. And Ariel, I don't know how you can listen to this like so many times. You say you get something new out of it every time, but you've probably heard this
I do.
presentation 100 times at this point.
You can always learn, because there's always a change or something. And I'm like, oh gosh, I didn't know that. Or a scenario, that has come up and people have not thought about it. So thank you so much. We will be sending out the presentation. If you did not get it in the chat, I did put it in the chat. We will be sending out the presentation as well as the recording. So as long as you registered for today's presentation and we have your email address, you will receive that as well as the additional follow-up emails and reminders. So thank you all so much for joining. We look forward to seeing you all next week. Rose, did you have anything else that you wanted to add?
Okay, I just wanted to thank everyone for coming, and I just learned a lot I was frantically making notes. I'm like Ariel, I was just frantically making notes because I thought I had everything, but you learn something new every time. And with being part of the aging population, and it's not just us of a certain age who need to have these documents in place. We want to emphasize that. But I just learned so much, and I look forward to being back. Let's say same bat time, same bat station next week, and for the following week. And so come on back and see us, everybody.
Ariel, you're muted.
Thank you all so much for joining. I realized that. We're so happy that y'all were able to attend today. And again, as Rose mentioned, we are really happy that you're here, and we hope to see you on next week. It's just going to get better and better. So you got to come back. So
we'll see y'all next week. Have a great one.
See y'all.